on this episode of Indiana Education Insight.
Well, I think one of the things, especially now with the changes in the statute, in terms of what's the value of your contract in the event that for some reason that you need to end that contract. Mm-hmm. And I think that what we had always done before, as Susan has already mentioned, is that you would generally take a look at that contract and say how many years are on that contract, and you would begin to negotiate a buyout. And a lot of times that would be about half of how many years that you had left in your superintendent contract. Mm-hmm.
Every week, the Indiana Association of Public School Superintendents is taking you inside today's Indiana education collaboration and tomorrow's education trends. We're staying on the pulse of public school innovators throughout Indiana and beyond. Join our conversation and contribute to our upcoming topics at iapssin.org/podcast. Here's your host, Dr. J.T. Koopman.
Welcome to another edition of Indiana Education Insight. I'm Dr. J.T. Koopman, Executive Director of the IPSS. Our weekly show features Indiana education innovators from all over our great state, discussing trending topics in the public education space and bringing in a variety of Indiana education innovators to hear their perspective. This show is brought to you by our IPSS team and produced by the friends at Site Strategics and Edge Media Studios. We're always excited to hear from experienced and passionate educators, so let's get today's conversation going.
Topics and trends in Indiana education.
Today's guests are Monica Conrad and Susan Traynor-Chastain, attorneys with Lewis Kappes. Mrs. Conrad and Mrs. Traynor-Chastain have been teachers and professors of school law in various Indiana universities, as well as numerous public speaking engagements. So both have been instrumental in shaping the conversation about Indiana public schools and their ability to look at education from various lenses, which is very important in this state of education that we have in Indiana. They've been a tremendous asset to public education, so let's find out how they view the issues in Indiana public schools. Welcome, Monica, and welcome, Susan. It's great to have you on today's show. Why don't we get started by having both of you just share a little bit about your background and the work that you do with Lewis Kappes.
Monica? Sure. Yes, thank you, JT, very much for having us come. I think that this is a wonderful opportunity, and we're very pleased that you've invited us to be here.
Thank you.
I am an attorney with Lewis Kappes. Prior to becoming an attorney, I was a special ed teacher and then worked several years as a coordinator in special education services. And with the overlap of just all that we do in special ed and the legal aspects, that kind of drew me into the law, and been practicing school law now for about 25 years. So, and have enjoyed it. It's always new. It's always interesting. There's always new challenges, and there's always new topics to have to kind of figure out when the General Assembly resumes and changes things for us.
Absolutely. How about you, Susan?
My background actually is in public sector labor relations. My undergrad degree from IU is in public sector labor relations. After I graduated from college, I worked for the Indiana Education Employment Relations Board for 2.5 years and learned all about mediation and impasse and unfair labor practices. And then based on that, went to law school, worked with private sector labor employers for a while. And then Marge Bannon Miller, who also used to do this kind of work, called me and asked me if I wanted to come to Bose-McKinney to do the work there, to do special education work with her, because I'd already knew how to do the collective bargaining and the labor and employment stuff. And like Monica, I've been doing this for about 25 years. And I will say, since the law changed in 2011, we could be doing this for 25 years, but probably the last few since the law changed have been the most exciting and interesting because there's so many new things coming.
Right. Well, you both are tremendously well respected in the education circles, and I know from a lot of your clients that they really appreciate all that you do. You have an interest in helping Indiana school leaders in a variety of ways. Please provide, if you can, somewhat of an overview, some of the recent changes that you just mentioned, Susan, about laws affecting superintendent contracts.
Well, we kind of thought what we would do is kind of just take a sliver of some of the new aspects that are hitting superintendents today, and that's looking at superintendent contracts.
Right.
I think that what happened a couple years ago is that there was a change in our Indiana laws with respect to having to do a hearing on a superintendent contract, and I think we've lived that for a couple years now, and that has created some interesting dynamics between boards, superintendents, and then their public. And we have a lot of clients that just having to go through that process can be a little bit unnerving.
Right.
And how you approach that process and how do you deal with your public. So now what we have is a brand new twist that came out of the last time the General Assembly met. And what we now have is that we have some term limits that the General Assembly has put into place with regard to superintendent contracts and how long those contracts can be in place. Because most superintendents had contracts in place with evergreen clauses. In other words, they would continuously roll over. And then the other dynamic that they inserted into the law is some limits with respect to if you did have a termination clause or a buyout provision, they've kind of put in place what that amount can be.
Sure.
And so that has created a new wrinkle into how we look at superintendent contracts, and it's quite frankly is going to be impacting us as we begin to move into 2018. I think many superintendents already had a contract in place before the law took effect, and so we're really looking at how this is going to play out in the upcoming years.
Okay. Is it your understanding that if a superintendent has an existing contract that is grandfathered?
If the contract, for example, I'm working with the superintendent now that has a contract that has an automatic 5-year rollover clause, and one of the things we're evaluating is, do we want to reopen the contract given the term limits in the new law and the hearing process?
Right.
And I think my opinion and what we've discussed is as long as we don't reopen it and have the hearing, the things that were permissible before the law changed continue to be because they're embedded in the contract and we're not opening it. But with the term limits, then I also worked with another superintendent recently who was completing their first contract with the district, and we had a conversation about, with the new term limits, what does that mean? Can you extend for 3 years? Can you extend for 5 years? Can you have an evergreen clause? When your contract expires, if you don't get notice by January 1, does it automatically roll over for 12 months? So we're having a lot of discussions, and then what would be most beneficial in terms of how you structure the buyout, because these laws, I think, were really prompted because there was a feeling that there was a lack of transparency.
Well, having had conversation with the author of the bill, it was going to be much different than the law actually came out, because she didn't understand the purpose for these provisions in superintendent contracts. And when I explained to her that it was about keeping a superintendent in place when a board had a good relationship with the superintendent and they wanted to offer some benefits to the superintendent, this was one of the ways that they could do it, as well as keep the superintendent in place without them moving to another district. She didn't understand any of that. And so it was helpful, I think, to kind of talk with her about that. And I also told her it's really unfair to a superintendent that has an existing contract. I said, I'm okay if you want to do this moving forward, but to grandfather any existing contracts that were in place, and she seemed to be okay with that. I think her main provision was the fact that she didn't want $1 million buyouts in place. And so if you can talk a little bit about that provision, that would be good too.
About the $1 million buyouts or the termination piece?
Well,
that's what prompted it, because initially, when you had a contract with the superintendent, the old statute said it had to be for a minimum of 3 years. So if you got into the board and the superintendent, they start down the relationship, the road to their relationship, and it's not working out right off the bat, the superintendent could count on, I have a contract for 3 years, and whatever my balance due on the contract is essentially liquidated damages and will allow me to go find another job.
Right.
And that's been changed now to limit it to 1 to 3 years, and then if you're coming off your first contract, up to an additional 5 years. So these term limits, if I have a contract already that has an automatic rollover clause, for example, do I even want to open my contract? Or if I'm a beginning superintendent and I'm coming off of my first contract, what can I expect in terms of the next one? How long will it be? Will it be a year? Will it be 3 years? Will it be 5 years?
And one of the issues that we have that, Susan and I were talking about before we came in is there's a little bit of conflict in the state statute right now, because it talks about that you can get into a 3-year contract with no more than 5 years on extensions. And that's in one section. We have another section that talks about how you can terminate the contract. And one of the things in terminating that contract is that the board has to give notice to the superintendent before January 1. Well, if you don't give notice before January 1 and you're in that 8th year, then, then technically under the statute, the contract doesn't terminate. And so I think some of these things we're going to have to probably address somehow as we look forward to new superintendent contracts, and how do we resolve some of that and take care of where the statute's left off.
And following up on Monica's point, there was language in the statute that automatically said failure to give notice by January 1 automatically rolled your contract over for 12 months. That language was removed, so it is ambiguous. What happens if you're in your last year, you don't get notice, and the statute no longer provides for the automatic 12-month rollover?
So not only do we have a new statute, but the previous statute was also revised.
Right.
Okay.
So some of the provisions in the prior contract, the minimum 3-year term ongoing, and then the 12-month automatic rollover for failure to give notice, those were both changed.
I think there's a lot of people that didn't realize that.
Yeah, the 12-month provision was taken out, I believe, in 2015.
Okay.
So then, of course, the question is, what happens if we don't give you notice? Does your contract just expire, or under contract law, do you continue to have a contract?
Okay.
But that doesn't mean that you can't, by way of your contract, address some of those places where the statute has failed to put anything in place as well. And so, those are some of the things that folks need to think about when they're looking at drafting their superintendent contract.
Because of the ambiguity in the law, to the extent that you can define it in your contract. So, for example, if you don't give me notice by January 1 to expressly say in the contract, then it rolls over for another 12 months. So that because the statute's no longer there, at least you have the clarity in the contract to say, well, my contract says.
So you have to actually put it in your contract, since the law doesn't speak to it any longer.
I think it's a good practice to do that, yes.
Okay. What are some of the other things that maybe superintendents should be looking for in their contracts, and specifically, what are the things that you help superintendents with when you're helping them negotiate their contract?
Well, I think one of the things, especially now with the changes in the statute, in terms of what's the value of your contract in the event that for some reason that you need to end that contract. And I think that what we had always done before, as Susan has already mentioned, is that you would generally take a look at that contract and say how many years are on that contract, and you would begin to negotiate a buyout. And a lot of times that would be about half of how many years that you had left in your superintendent contract. And so now, by way of statute, it says your contract can be 3 years and extended for no more than 5 years. So that concept of that is of what the value is has been somehow shortened. But then more to the point is that in the statute, you can only do a buyout that is no more than 1 year of your salary, or $250,000, whichever is the lesser amount. But it also has excluded in that calculation any kind of benefits. So I think that we need to kind of look a little bit closer at what benefits are, and what those benefits mean in terms of those termination provisions. Benefits could also include bonuses. And so we are beginning to see a lot more of a trend now of having something in place for some kind of a bonus provision for superintendents. I do think that we do have an instance out there where there's been some questions raised by the State Board of Accounts about how you treat those bonuses, in terms of making sure that they're well defined and making sure that the board has approved those when every year that bonus comes up and becomes available.
Right.
So I think that I think we are beginning to see a lot more creativity in what you're going to do on bonuses, what you're going to tie them to, how you're going to define those. And again, those, what can, we want to be able to think about, what does that mean in terms of even a termination provision?
Okay.
Some of the other things we talk a lot about is how are we going to define the compensation, because the law now requires us to have that hearing. Is there a way to write your compensation into your superintendent's contract to allow for increases in salary, tie them to some kind of criteria in the contract to allow, how do you address your fringe benefits? Do you identify it as a flat dollar, or simply say what it will be? People are much more conscious of, how do I write my contract so that, that it it's as clear as possible, and we don't have to have a hearing every
Sure.
year.
You know, there are a lot of new superintendents that don't even seek counsel for their contract. What kind of advice do you have for new superintendents?
I think that it probably doesn't hurt them to at least have somebody to take a look at that contract or help them as they go into that negotiation process.
And I know I have heard from some of my superintendent clients that new superintendents will call them and say, "Can I look at your contract?" and maybe use their contract as a template. And for that particular superintendent, if they're long-term, their contract may have a number of benefits that a new superintendent walking into a new board, the new board may say, you know, that's quite a lot of expectation there.
Right. Yep.
And so they need to be careful about how they bring their terms to the new board.
I think there's other dynamics too that we're seeing more recently in terms of board superintendent relationships. You know, one of the things that Susan and I have kind of talked about and kind of kicked around is that we've seen, you know, in any standard contract, you would spell out the responsibilities of each party. And so, you know, maybe taking another look at superintendent contracts and how well are we defining out what the responsibilities of both parties are for a healthy relationship
Sure.
between that board and that superintendent.
Yeah.
And what the expectations are, because usually in the superintendent contracts, the expectations of the superintendent are usually set out fairly clearly about, you know, we expect you to work this many number of days, you're the CFO if you want to go do something, or the CEO if you want to go do something else, you have to come and get permission. But what you don't really see then on the other side is what your expectations for the other party, in this case the board.
Right. So just as a general question, when is a contract not a contract? It seems like to me that when a board decides that they want to terminate a superintendent, the contract really doesn't make any difference.
Well, I guess the question is how you're defining termination, because the contract doesn't end until it's all over.
And
Maybe I think we've seen a number of situations where people aren't sitting in their superintendent office; they're still out there and they're negotiating how the contract's going to get terminated. So that word termination of contract is probably kicked around in a lot of different contexts with different meanings.
Another example that I have seen is, especially, it's more applicable to building administrators, but it's probably something superintendents ought to consider, is the case law distinguished between whether your contract said, I am principal of XYZ building, or administrator. Because if it said administrator, you could be moved around without any hesitation. And what I have seen in some superintendent contracts is language that says the superintendent position is unique, therefore you will not be removed prior to the end of the contract or put into another position.
How does that interplay with the fact that, generally speaking, not only do you have a superintendent's contract, but you also have a teacher's contract? How does that play out?
In terms of termination, what you'll look at, if you have, let's say you have a new superintendent, 3 years on the contract, it's not working out. One of the ways, because the superintendent has to be employed if they're licensed on an underlying teaching contract, the administrator contract depends on the underlying teaching contract. However, if you cancel the underlying teaching contract, that automatically voids the administrator contract. So then the board would have to be looking for, well, how, you know, do we have cause?
The other aspect of that is again looking at how that termination of that contract, you know, plays out. Because under the statute and under what we currently have in the superintendent contract termination provision, you know, it talks about that the superintendent then gets a meeting with the board. And now what you've seen in the last year or so is some opinions from the access counselor that says that meeting has to be in public. So that also raises some other questions about how we're going to deal with some of these things through that contract provision. You know, how can it, you know, raising questions in terms of negotiating that superintendent contract of, you know, an opportunity to have, you know, any kind of deficiencies identified and an opportunity to remediate any of those deficiencies. We've got some of that in the teacher contract law. You know, but have we ever played some of that out in with regard to superintendent contracts? I'm not so certain that we have. And so, you know, the process for which we, you know, because with teachers, you would have the preliminary notice coming from the principal, and then you would have the opportunity to meet with superintendent, then you have the opportunity to meet with the board. Well, we don't have that same kind of a process right now in terms of superintendent. So But there's nothing that would prohibit folks from looking at closer at what that process needs to look like through some type of superintendent contract.
Okay. Susan, you were going to comment?
Right. And in terms of writing it, in terms of termination provisions, what we have done, some of the folks I've worked with, what we've done is we've written alternative means of terminating the contract. We have, for example, conviction of a crime, or if you lose your license and that's required for the job, that's one cause. The other one is termination for cause, obviously. And then a third one is kind of like a no-fault clause. If we just decide, look, this isn't going to work, the superintendent will give the board 12 months notice, and at that point then they will part ways and define what the pay will be in that case. So if you decide you want to shorten that 12-month period, do we pay you a year's salary? Do we pay benefits? What would we pay you? And this change in the law that says you can only have up to a year's salary or $250,000 really kind of plays into that.
Okay. All right. Well, that also, if you have it defined that way in your contract, and the board signs it and you sign it, but then when it really comes down to that and the board reneges, where do you go from there?
Well, that's what we're beginning to see is that superintendents usually engage an attorney to help them kind of get things wrapped up.
Mm-hmm. Yeah, and it does take that, unfortunately.
And I've seen some situations recently where the superintendent has done absolutely nothing wrong. It's just simply you have a new board or a change in board, and the new board will come in and just say, we want to go a different direction. And in that situation, even if you've just renewed your contract or have a new contract, what do you do?
Yeah.
And as Monica says, the board's attorney will work with whoever the superintendent's counsel is to find some kind of positive exit strategy.
Yeah.
I mean, in all fairness with school boards, and in talking to school boards, many of your school board members are not teachers. They're not in the public education system. So this idea that people have contracts and contracts will continue through the entire school year is a little bit less than what they're used to from their own employment situations.
They're more accustomed to the private sector at-will model.
Right.
And so this concept, and then because we're public employers, we also then have the constitutional issues that overlay the contractual issues. School boards don't always understand, and it's frustrating for them. They're used to the private sector model of if you're not doing your job, you're gone.
Yeah, right. Sounds very, very complicated to me, and gets more and more murky as we move forward. What kind of advice do you have maybe for somebody that's new to the superintendency?
As they're approaching getting into becoming a superintendent, then, I think, as Susan's kind of pointed out, is one of the things that superintendents do tend to do is they call their buddy, they call their friend, say, give me your superintendent
Absolutely.
contract.
Yep.
They may doing that, they may end up selling themselves short in terms of looking at that superintendent contract and what might need to be in there in light of the new changes. So I think, the first step that anybody who's going to be approaching that superintendent position probably needs to be contacting, you and just saying, okay, JT, you see a lot of contracts out here. You see a lot of things out here with superintendents. That's probably the first call that they need to make in terms of, getting that guidance just to get started in that process. I think that's probably one of the first calls they need to make.
Unfortunately, I don't get that call.
Oh, really?
I get the call when, oh my gosh, I'm in trouble, now what? And so that's when I call you and say, I've got XYZ superintendent that needs some help. What can you do for them? And so it appears to me that, at least from the association's perspective, is we need to be more proactive in helping these new superintendents. Would you agree with that?
I would. And another question I guess I would have is how educated really are they in the process of how this works? I mean, certainly you can read the statute, but as practitioners out in the field, we actually see how the negotiations work with the school board and where are the pitfalls, where are the hot spots.
Right. And I would like to say that the superintendency is changing in multiple ways. This is just another way that the superintendency is changing. And, you've brought up some points about the way the law was written that has now been redacted. And perhaps I need to go back and take a look at some of that information myself with your help, if you would
Absolutely.
So grant that. So in closing, anything else, any advice that you want to give to our superintendents or, young or experienced, either one?
One of the things that I think we're seeing as a pretty consistent theme, usually your your boards that hire your superintendent, that board is probably the best board that you're going to have,
Right.
and that board's going to work with you. I think that what begins to happen is that you end up getting new board members, and you as superintendent end up having to pretty much train them about how things work in schools. Um, having the patience to do that, and then you have just the dynamics that you have amongst board members working, amongst themselves. I think that probably the most difficult job of a superintendent is trying to keep all those people kind of on the same page,
Right.
focused on the same things and
Yep.
what the school corporation needs, and kind of keep people from deviating from that. I think that job of doing that within a school district is becoming harder and harder. I think what we have seen is that the accountability on schools has increasing year after year. We've seen a lot of accountability with regard to just test scores and what it means to be a good school, and how schools are rated. We're beginning to see more and more in terms of just that fiscal responsibility. Superintendents have the responsibility to be the chief of curriculum, the chief of the finances, the chief of transportation, and everything else that's going on in the school district.
Right.
And and trying to help that school board to understand what is the highest priority that we have facing us, and what do you do as a board to kind of stay on page of that, and let's kind of work on those pieces. So I think in some of those districts where you see that the board and the superintendent has done a lot of strategic planning and spelling out, what is the most important things that the school corporation needs to focus on, and there's some kind of a plan in terms of what they're going to put in place around that strategic plan. That all comes around good communications, and that good communications about having aligned expectations and goals.
Right.
So where I think sometimes that things kind of get off is that where you have boards and superintendents who then end up having a difference in where the corporation needs to head.
Right.
Something else we do, especially if you have maybe a turnover in the majority of the board, or when you have new board members, we will do training to help each party understand what their roles are, because sometimes those lines get blurred. So the superintendent is responsible for doing these things.
Right.
And you as a board, you're a legislative body, you are responsible for doing these things. Because I've seen, and I'm sure you have in your experience, sometimes where the lines get blurred, and you may have board members that have a certain expertise that want to come and provide that and assist you.
Mm-hmm.
And, so we do training about, what are your roles as board members? What is the superintendent's role as being the educational leader of the corporation? And that has been valuable.
Well, I think you all point up great points. I want to make sure that we get all of the points that you wanted to cover discussed. So are there other things that you want to bring up that we haven't touched on?
I think we've kind of covered a lot of things. Other than, again, I think that the superintendents that are going to be entering into this whole contract process probably need to make their first call to you and say, what do I need to know, and what's changed, and what ways can I begin to look at the aspects of a contract first, with my board.
Well, and I don't disagree with what Susan has said.
Mm-hmm.
Generally, they're going to call the friend that has a contract, and maybe that's not the best way for them to be doing business, especially as superintendent contracts have changed. And so,
And if you're a new superintendent, understanding, as I mentioned earlier, the changes in the law in 2011 have changed the job of the superintendent significantly, because we have accountability, we have performance-based compensation, things that we didn't have before, and so there's going to be a lot of demands on the superintendent to make sure they understand those issues so that they can communicate, and as Monica said, communicate and work well with the board, and so everybody understands how they work and what our roles are.
in most places, in many places, the school district has the largest budget, is the largest employer with the most employees, and lots of complex moving parts in a school district. And should those things be reflected in the superintendent's contract as far as compensation is concerned?
I have seen that where, and especially with the accountability, I've seen a superintendent is specifically brought in to help raise the school grade, help raise the I-STEP scores, and the contract reflects that, and they're writing in, if you get your I-STEP scores to this, or recognizing that perhaps you're in a district where folks are not inclined to stay, and having, if you're here 5 years, adding a bonus in that situation.
Right, right. So those are some of the bonuses that enhance a superintendent's contract, especially if the board-superintendent relationship is a good one.
Right.
Oh, good.
And those can also be kind of, if you do strategic planning, aligned to your strategic plan as well. And I've seen that where a couple of superintendents have put that into their contract so that, it kind of says we're all going to be on the same page of this.
Well, superintendent board dynamics are ever-changing and are always interesting to me. And, of course, in our profession, we say the board that hires you is probably not going to be the board that fires you. And you can do a lot of things as a superintendent, but you don't mess up the money. So those are my 2 points of emphasis to superintendents, is just let them know that that's the world they live in. And if they don't know money, they better find somebody who does know money, because finances will get you in trouble quicker than anything. So, well, I really appreciate both of you being with us today, and your comments are right on target, and I just hope that I can get new superintendents to have me being that first call so that I can refer them to council to help them with that contract. So I think that's a great advice.
Well, thank you for having us. We really appreciate the opportunity.
Oh,
Yes, thank you, JT.
Absolutely. Well, now it's time to wrap up this episode with my take on the current state of affairs in the Indiana education landscape.
Dr. JT's closing comments.
Unfortunately, after 6 hours of testimony by teachers, parents, principals, and superintendents who were asking for time to collaborate on the plan for a public meeting of the State Board of Education, who is attempting to implement the concept of graduation pathways. However, on a vote of 7-4, they passed a set of ill-conceived and unvetted recommendations that will negatively impact our graduating students. Although state legislators have called for less testing, this plan implements more testing, and the plan has no understanding of fiscal impact. They want to assemble the plane as it flies, and we all know that that doesn't work well. Additionally, it will negatively impact graduation rates, which will falsely create the perception that schools are not doing their jobs. It is my hope we can get our legislators and our state leaders to see the value of public schools and the nexus of promoting public schools and economic development in Hoosier communities. I see these as investments in our children and not as an expenditure. Perhaps we can pursue this issue and others in another segment. On our next show, January 15th, we welcome Mr. Tony Bagshaw, an educational consultant with Battelle for Kids. Perhaps he can provide some additional insight into the State House and education. Join us for that and more on the next Insight into Indiana Education. Thanks for being part of education. Please stand up for Indiana Public Schools.